Um, Hello, everyone. It's Allison Scouber, Consolidated Planning Group. We are excited to present this presentation to you today. We're excited to have Boyd Handley back with us again on the ever popular topic of guardianship and alternatives to guardianship. This is a question that we are really, there's a lot of questions surrounding this and what to do and when to do it and how to do it. And are there options of partial? There's so many questions that surround this topic. So we're really, really glad you're here today. So today's event is being recorded. You will get an email either later today or tomorrow with this recording that will also have the slides. You guys are muted, your cameras are muted, and your mics are muted. If you have questions throughout the presentation, please put them in the chat box. We are going to get to as many questions as possible today. And without saying any more, I'd just like to turn it over to Boyd Handley with the Handley Law Office. Thanks for being with us today, Boyd.
Oh, thank you, Allison. We'll get going here. You want to say anything about that slide, Allison?
Carry on. I
right.
want to get to the meat and potatoes of guardianship.
All right, sounds good. Well, unfortunately, everybody, I have to give you a disclaimer. This presentation does not create a attorney-client relationship. And also want to tell you that all this is general information. Each person's situation is very different, and there's different ways to solve problems. So just look at all this as in general, and then depending on your situation, you can go forward with that. Just a little bit before we really get into this, I'm a father of a daughter with special needs who my wife and I have guardianship of. She's 26, so I've been on the same side of the street as you have from a personal standpoint. And a lot of my practice deals with what we've done for my daughter. Overall, I talk about a special needs toolkit, and we're going to talk about the left-hand side of that toolkit, which is today guardianship and the alternatives to guardianship. Again, we're going to, some of the alternatives to guardianship, we're going to talk about power of attorney, medical power of attorney, and decision-making agreements. In Texas, why do we need guardianship? Well, unfortunately, when our kids turn 18, they become adults. And in many situations, when our childs have special needs or disabilities, they're really not ready to go forward into the real world. And without a guardianship or maybe an alternative guardianship, we as parents cannot do what we were doing for them when they were 17 years old. So that's what we'll be going over today. When someone comes into my office and tells me they need guardianship of their child, I basically look at it, well, do you really? And this is something that's been put out by the American Bar Association. And I actually look at that and go through that with the parents and try to understand why they're in my office, why they think their children needs guardianship, and we proceed like that. I will say that with us, guardianship is an extremely emotional time for parents. I know when we did my daughter, Caitlin, we were still, of course, in court. Nowadays, we're doing everything by Zoom, so it's not quite as challenging. But with guardianship, you're taking away the rights of our children. And it's extremely difficult to make that decision. And really, when we made it, we knew we were going to do it, but it was like someone hit us with a baseball bat. It was just all of a sudden it hit us that, oh, she's 18, we've got to make a decision. So, I try to talk with my clients, and try to help them emotionally, because it's hard to determine on how to go forward with this. And, also want to point out that, we'll go over this later, but it can be a partial or full guardianship. So everything's not straightforward. Just want to let you know that in 2015, Texas legislature passed two major bills. One was alternatives to guardianship. We've always talked about this, but now we're required by law to go over those and be sure that none of those work before filing for full guardianship. The other one that was passed is supported decision-making agreement, and that's excellent document to work within the gray areas of whether you need guardianship or whether power of attorney and medical power of attorney does not work. As I mentioned before, there's full impartial guardianship. There's guardianship of the person, of the estate. In most cases, when our kids are turning 18, it's going to be guardianship of the person. Guardianship of the estate deals with maybe an adult that's been in a catastrophic accident and becomes incapacitated, or you may have an elder, your parents, or someone that you know that may have dementia that did not have a power of attorney, a medical power of attorney. And that's when you do the guardianship, the estate. And then in some cases with elderly or older people that have maybe been in an accident, then you may have guardianship of the person and the estate. Temporary guardianship maybe comes in when someone's in the hospital, maybe in a coma, that they need someone to help them do things, and we can do a temporary guardianship for that. Or if you've got in your wills someone named as your guardian and you and your spouse die in an accident, and that guardian may be out of the country. And what we can do is have a friend do a temporary guardianship until that person can get a visa, come into Texas for the hearing, and they have to be present for a hearing. Of course, nowadays we're doing it by Zoom, so that may take some of those issues off the table. Again, full or partial, and guardianship is not permanent. I'll let you read through this, but I was able to sit in on a court hearing a couple of years ago where a young man was getting his guardianship given back to him. He was nonverbal. We were talking to him through his voice electronic contraption. I call it my machine, but I'm an old guy. And we were talking before the hearing and having a good conversation, and then there was no teary-eyed left in the building when he was getting his guardianship. And that's the first one I've ever been in, and it was fantastic. So I always like to tell parents that story because, if your young one turns 18 and they may not quite be ready yet, you don't have a guardianship for a couple of years till they mature. And even though it costs money, you have to go to court. But what we're doing at the end of the day is protecting our kids, and that's the whole reason behind all of this. We won't go through all of this, but here are the guardianship rights you can take away. The first 5 are the major rights that are taken, and then we add a lot of the others. I have a number of clients who still are allowed to vote. I have 1 or 2 that have a driver's license. Not sure how much they drive, but you can pick and choose depending on your child's disability or their ability to go forward in life. Guardianship of the person, again, with our kids turning 18, this is a majority of the ones that I do for those clients. And it's basically what we did for our kids prior to them turning 18. Not a lot of difference here. You'll still have the a bank account, probably a rep pay account if they're getting SSI. And basically it's just being a good parent. But by law, we have to go through this when they turn 18. Guardianship of the state, in most cases, this is going to be an elderly person that has houses, accounts, and things of that nature. Very more detailed than guardianship of the person. You have to file reports each year, tell the court how the money is spent. So a lot of work goes into a guardianship of the estate. And in most cases, this won't be needed in our situations.
There's some confusion on the guardianship of estate because a lot of times, well, obviously, if we're getting guardianship of our child, then they don't have the capacity to handle their own money. So some people think if that's the case, then they should have guardianship of the estate. So are you saying that basically guardianship of the estate is for people that actually have assets? So your average person that's getting SSI that has less than $2,000 assets, basically there's no need for that?
Yeah, the court's not going to give it to you anyway, unless you have a lot of assets, houses, retirement accounts, land, and things of that nature. Then it's going to be guardianship of the person. In my situation with my daughter, of course, my wife is the rep payee. She has a rep pay account. That's the only account my daughter has. So that's going to be usually the cases. And, if these kids are turning 18 and applying for SSI, if they do have more than 2,000 assets, and, we try to put those into the trust. So again, you're getting back to that situation where that's guardianship of the person.
As guardianship of the person goes, if we have a person that maybe is on the spectrum that can voice their own opinion, but mentally they're just not there, is that a slippery slope? Could you expect to get guardianship? Could you expect what if that child is 18 and adamantly is voicing that he doesn't want guardianship even though his capacity isn't there? How does that work?
Yeah, well, when we go to guardianship, you're going to have the court will appoint an attorney ad litem, and that particular person will talk to the young adult and ask him or her if she wants guardianship. And if that person says no, I do not want it, then the parents or the proposed guardians will have to prove to the court why that child needs it. I've had guardianships of individuals with 125 IQ, but they had mental issues, and we were able to get that by the court. Of course, they were not saying they didn't need the guardian with that, but that's normally how it works. Now, if you've got an older person that disputes the guardianship, then we would have a contested guardianship and would actually go in front of a bench trial in front of the judge for that. And that, what we would do if the ward, well, unfortunately, what we call the people on the guardianship, the wards, which is a terrible name, but if they tell the attorney ad litem that they do not want mom and dad being guardian, then we would have to go to the court, which we do anyway, and then give reasons why the court needs to appoint the parents as guardian. But in most cases, I haven't had an issue with that. From the guardianship steps, you can file 180 days prior to the 18th birthday. I normally like to do that and get everything done. We also have to have a physician certificate filled out by a physician. I've got a picture of one of those here shortly. And basically what that does is to tell the court how the disability affects the child or the young adult in his everyday life. And it's also very helpful if you've got parents that are on the borderline. Do I need guardianship or not? And I always let parents fill that out themselves and look at it and see, okay, this is really how the disability affects my child on a daily basis. And it's very beneficial. That physician certificate can only be filled out within 120 days of filing. I've had a number of parents that have had their child evaluated 6 months ago, even though the physician fills out the appointment today. So we have to be sure that the child is within that 120 days being evaluated. The only other thing that, that's kind of unsettling is that you're going to have a constable serve your child with the citation about 2 weeks after we file it. I know with Caitlin, she was excited to see the constable with her being served, but it's a little unnerving to have a constable knock on your door. I mentioned before that you're going to have an attorney ad litem appointed by the court to represent your child in court. And basically they'll come out and interview you and the child, look at where the child's bedroom is, look inside the house, see if it's good conditions. And probably 90% of the cases, they're doing that by Zoom now. If your child has any older siblings, we're going to have to serve them with a waiver agreeing with mom and dad being the guardian, excuse me. Even if they're half brothers and sisters, they have to be served also. That's usually done. I do that by certified mail. There's also a training course. This was done probably in 2015 or somewhere in that range, where it's basically a PowerPoint presentation that you have to view. It takes about 30 to 45 minutes. You'll get a certificate, which we have to file with court. When I did my daughter guardianship, almost 8 years ago now. We didn't have to do this. I took it 2 years ago just so I wouldn't have to tell my clients they have to take it and not know anything about it. When I did it 2 years ago, we actually had questions we had to answer. I heard the other day from a client that you don't have to answer any questions anymore. So it's a very simple one, but it gives a good evaluation of what takes place and what you have to do as a guardian. So it's actually a fairly good course. I mentioned the physician certificate. I did this basically. You can't see what you can't read anything, but it just gives you an idea about what's in it and kind of what it looks like. It's 4 pages that the physician or psychiatrist can fill out. On the right-hand side, it has cognitive deficits, ability to make responsible decisions, and developmental disability. And it has a bunch of checks on that, yes or no. And so it really gives you an idea about on a daily basis on how the disability affects. And the court requires this, and they look at it, the judge looks at it, and it really helps to prove to the court that your child needs guardianship. I will say that the courts in Harris County, Montgomery, and Waller are fantastic. The judges are looking after the young people. They really don't care if the parents, well, I won't say that, but they're not looking at the parents being the guardian. It's what's best for the child. So I've been extremely impressed with all the judges. They're very compassionate. And we just got a good group here in the surrounding counties when you go to court. And again, it's all done by Zoom, so it's not as emotional as actually standing in court. And most of the time, you don't have to have your child with you. If he or she is in a routine, a lot of these kids really, it's hard for them to get out of a routine. And so if the physician certificate says that they can't attend or it wouldn't be beneficial to attend, then in most cases, the judge will allow the child not to attend. Who can qualify for guardians? Almost anybody, as long as you're over the age 18, as long as you don't have a felony record or criminal history. I've had a case going on now where one of the parents had a criminal record some 30 years ago. We still don't know whether that person will be allowed to be guardian, but we sent a lot of information in with letters from people saying that this person has changed over 30 years, and we're hopeful that will take place. I did have a guardianship that I was the attorney ad litem in a number of months ago, where one of the parents had a DWI 2 years ago, and the judge would not allow that person to be guardian. He did tell the person to come back in 2 years, and he would reconsider it. So I have to say these judges are really looking after the young person that's going through guardianship. And when you go through guardianship, the court, it looks after your child. I mean, your child is now part of the court, and they're supposed to check with you once a year and visit your home. You have annual reports that are due once a year on a 12-month basis. And then your guardianship letters that you get are good for 16 months. And you really have to understand that you have to turn your annual report in once a year at the 12-month period, but then you have another 2 months to reapply for your guardianship letters, and then the court gives himself another 2 months. So that's how you get to 16 months in order to get your guardianship letters, which are renewed each year. Alternatives to guardianship. Most of the ones that we talk about when these kids are turning 18 is the power of attorney. There's a statutory power of attorney and medical power of attorney, because you need a medical power of attorney to make decisions for your loved one with a physician, and any contracts or banking, you'll need the power of attorney. The issue with that is that these kids have to have the capacity to understand the legal ramifications of those two documents and to understand what it's saying. There's a lot of legalese in those documents. Legalese means legal writing. And it's almost hard for regular parents to understand what they're signing. So that's the problem with the medical and durable power of attorney. One of the things that the legislator did was do a supported decision-making agreement. That is gray on the capacity needed to sign that. So a number of parents that are still on the borderline that their child may not be able to sign a medical power of attorney. They may not at this point have the money to go forward with the guardianships, although there are some uh, uh, agencies here in town that will do that pro bono. Then the decision-making agreement is the way to go. With our situation, my wife is the representative payee, and that takes things. But if you've got a high-functioning child, you can have bank accounts with you and the child on it. But what I want to mention is that what we have to understand is that when our child turns 18, they can be taken advantage of. And it's almost like an elderly person. Someone can come to them and ask them for money or ask them to sign a contract or things of that nature. So that's really what we're trying to protect our children from with a guardianship. I will say that I've had a number of clients that have had kids with fetal alcohol syndrome, which is a condition where during gestation the mom was drinking, and at birth there's actually part of the brain that's missing. And these kids are normal kids. They can have a high IQ, but they have extreme anger issues. So sometimes I tell these parents to really look at their child if they know they've got that situation at age 18, because, and then if they have some other disabilities too, because what happens with a power of attorney and medical power of attorney is that if some of these kids wake up one morning and get mad at mom and dad, then they can revoke the medical power of attorney and power of attorney, depending on who they say it to. So that's one of the issues with that, is that they're revocable anytime the person that signed it does not want the other person to help them with. We mentioned this, mainly you've got to have the mental capacity to sign these two documents. And, parents could actually do this, go to Kinko's and have it notarized, but there's a liability here. If something happens to the young person because of that, and a third person says mom and dad is not doing what they're supposed to, and the medical power of attorney and a power of attorney, and the child or young adult didn't have the capacity to sign it anyway, there's some liability issues. So keep that in mind. Again, yeah.
Can we talk about this supported decision making, and if it's even really a legal document? And because I know that supported decision making is kind of a Texas thing. Some other states have it, just like guardianship is a Texas thing. So if you've got guardianship from another state, they need to see an attorney, right? Is that
Yeah.
correct?
Yeah, I'm actually doing a transfer of guardianship now from a northern state to here, and it's basically the same thing as going through a regular guardianship, although the attorney ad litem is not part of the situation. So what we have to do with that, we have to have a certified copy of the total court record from wherever they're moving from to Texas, and then file that with the court, and we'll have to go through a hearing also. Also, if you change counties, if you get guardianship in Harris County, we actually moved about 2 miles outside from where we used to live, and we went in Fort Bend County. So you have to transfer the guardianship to the new county. Very easy to do. You don't have to go to court, but that is required. Regarding supported decision-making agreements, it's in the code. So it is a legal document. There are different ones. I don't do them in my practice. I actually download some from the Arc of Texas and give the clients. But basically what it is in the code. So you have to abide by it. And it's very good. Now, what the issue with that is that, as I mentioned, the level capacity is gray. So you can actually have someone that doesn't understand it fully to sign it. And what this does is will allow you to go into meetings with your loved one, explain to your loved one what the meeting is about, and then your loved one will have to make the decision. So, it's that gray area. If your loved one has the capacity to make a decision, that's great. I know in a lot of schools, you've got these kids that are signing their ARDs when their parents do not have guardianship. And I know in a number of cases, they do not have the capacity to sign that ARD. So, but it's happening and it does happen. But what parents need to understand with this is that this document will only allow them to assist their loved one in explaining, and their loved one has to make the decision. I know this is they probably use it for different things other than that, but from a legal standpoint, that's the only thing they can do. And again, this is good if your child doesn't have capacity for power of attorney, medical power of attorney, you don't have the money for guardianship, then this is probably some people's only alternative. And even if they can do a power of attorney, medical power of attorney, go ahead and have one of these done also with that. This may help you get into some of the meetings that the power of attorney may not allow you to.
And on the power of attorney and healthcare power of attorney, I think it's just important to note. I know that we're talking about special needs here, but I like to encourage the families that we serve that this power of attorney and healthcare power of attorney is at least the healthcare power of attorney, at the very least, is a really good document to have on hand for your neurotypical kids that turn 18 and are going off to college. And now
Absolutely.
that we're having this conversation, this is a really good time to think about what do your parents have or your grandparents have, and have deliberate conversations about these things, because oftentimes it's after something happens. Something bad has happened and the right documents aren't in place. So as you're thinking about this, mark this down to just really check, do you already have this in place? Do you know what your parents have in place? It's just, I think that that's just an important thing to check on before it's too late.
Yeah, absolutely. From a personal standpoint, my mother-in-law was in an accident a couple of months ago. Thank goodness she's fine now. But she was taken to the hospital. She was a little groggy. She was getting pain medicine, and unless my wife they would not let my wife in the hospital unless she had not had the medical power of attorney. And she faxed it to the doctor, and she was actually talking to the doctor from the parking lot. That was one of the heights of the COVID. So it's very necessary. A lot of our parents do not want us in their business, and you can tell your parents have these signed and name one of your children as power of attorney, medical power of attorney, and it's not effective. Well, we can make it effective when you sign it, or it's not effective until you're incapacitated. And if your parents really don't trust you, we can have two doctors in to declare you incapacitated. But if you don't have these documents, the only thing you can do to take care of your parents if they have dementia or become incapacitated is to get guardianship of them. And that's insane to do that when you can talk to your parents and have this done. Luckily, my parents, before they died, they had me power of attorney, POD, payable on death, on their checking accounts. I had the power of attorney, medical power of attorney on them. So I was able to take care of them until their death in the nursing home and things of that nature. So, I thank you, Allison, for mentioning that about these college kids, because, if the kids go out and have a wreck on the way to A&M or somewhere, you can't call the doctor if they're over 18 and ask if they're hurt or what's going on with them without the medical power of attorney. So extremely important. And it's almost more important than the wills. We're not going to get into wills today, but this is for while you're here and taking care of your loved ones. So extremely important. We've covered all of this. Again, number 2 is what we just talked about with our parents. And your child turns 18, you can no longer look after them unless you have the legal documents to take care of them. And one thing I tell parents is that, have a will done, in your will have who the guardian is going to be. Whether you have minor children, you need to name your guardian in your will, because if you don't name a guardian in your will, then the court may decide on who's the best person to be guardian for your child, although at the end of the day, the best person will be named. But what happens in your will if you've got a minor child, then name who's going to be the alternative guardian. What happens if both you and your spouse or partner die in an accident, then whoever that guardian's name or your executor in your will can take your death certificate with the will and go to probate court and have that person named guardian of your loved one. The main thing with that, especially if you've got guardianship of your child like we do, we have those named. I've done that a couple of times and it works very well, because at the end of the day, the judges are looking after the best interest of your child.
Is there a such thing in Texas, Boyd, of having joint guardianship, or like can there be two people?
That's correct. You can have, there's only two ways to have joint guardianship, is with the biological parents or with one biological parent and one step parent. What happens is that the biological parent that's not the step parent has to give up the right and agree with the step parent as being the guardian. So that's the only way you can have a biological parent and step parent. But yes, those are the only two ways you can have co-guardians.
Which brings me to a next question that I'd like to bring up, that it comes up every single time, Boyd. Let's say, for instance, there's a divorce situation and the one parent doesn't think guardianship is necessary, the other parent does. How does that work? And then also tell us about the absent parent that is not living in the United States or outside of Texas or what have you.
Yeah, we'll go to the first question first. If you've got one parent, that is absolute. And I have to say that, you know, as being a parent with a child with special needs, you know, it's extremely difficult. You may have one parent that agrees with the disability and one doesn't. I've been very lucky with my wife, Carrie. She's the brainstorm of the group as far as knowing everything about disabilities, but we've always agreed on everything. And we've had a very great relationship, even though we've got a daughter with special needs. But it causes a lot of issues with families and a high divorce rate. If you're filing for guardianship and you are divorced and the other parent does not believe in it, you can file. That other parent would have to hire an attorney and go in and contest a guardianship. When one is going in and filing for guardianship, we have to serve the petition on the other parent. If that parent's missing, we have to have a constable serve the last known address, whether he or she is there or not. That's all it takes. And if it's overseas, we still have to have them served I've done one in Mexico before, but you have to have one of the local law enforcement serve that parent at the last known address if they're overseas. If we can't find them, then we have to do a affidavit noting that we have no idea where they are. But if we have some last known address, or that's what we have to do, and that's how that's handled.
I think you mentioned before that you could start the guardianship process 6 months prior to the child turning 18. About how long does the process take? And then talk to the families that maybe they've got a kid that's 24 and they didn't know about this then, or they didn't do it. Can they still do it?
Absolutely. The only difference is if the child is over 18, then even though we're supposed to talk about the alternatives to guardianship, we really have to talk about the alternatives to guardianship if they're over the age of 18. And basically, I've had one judge that made me go through almost every one of the alternatives, noting why we couldn't do that, why guardianship is needed. But absolutely possible. It's no problem in doing that with that. Mm-hmm. I believe you had another question that I forgot. Sorry.
Let's see here. It'll come back to me in a minute.
Okay.
I've actually got another one. Basically, biological parent and adoptive parent, if you have a legal adoption and you have adopted that child, it doesn't go back to the biological parent. It's the
That-
adoptive parents,
That's
correct?
correct. Once you
Okay.
adopted biological parent does not have any rights anymore. Mhm.
Okay. And we got somebody from the audience. How long does the process take
Oh, yeah,
typically, the
that was the
guardianship
question.
process? Yes.
What I'm seeing in my cases, the quickest I've done it, and that was with someone that was already turned 18, was 55 days from start to finish. I'm seeing, and that was rare. I'm seeing about 95 to 135 days with the COVID and the courts. So that's why first of the year, I was actually having to get court dates 2.5 months ahead of time because everything was filled up.
Mhm.
It's not quite as bad now, but uh, 55 at best, 120 something at most as far as the timing. That's if someone's already 18 and you're counting it. Most cases, if they're not 18, we file it prior to the 18th birthday. We can probably get a court date either the week or the week after. Now, the issue that you have, and it's not the court's control or my control or your control, is that if you get an attorney ad litem that's extremely busy, you got to work around their schedule too. So I've got one now that's busy for the next 2 months in the mornings. So I'm in the process of getting one of my cases transferred to another court that has afternoon cases. So, we try to work around it the best we can. Mhm.
Sure.
I think that's all I've got. I think you've got one
Okay.
slide at the end.
The inquiring minds always want to know, what can I expect? And, I know that, like me, I don't give prices out in a group setting or something like that because everybody's situation is vastly different. But in a non-contested guardianship, start to finish, can you give them a range? So as people are planning financially, what they could expect, kind of a price range of what they could expect to pay for guardianship?
Yeah, they're going to run with all the fees, the court fees, the attorney ad litem fees, probably low end 3,300, high end really depends on the law firm you hire. It can go up to maybe $5,000. So, but that's all the fees included, which
Okay.
is the filing fee, the attorney's fee, the attorney ad litem's fee in Harris County. It's maxed at 600. In Fort Bend County, it's wide open. I don't like that, but it's wide open. But 90% of the time in Fort Bend County, the court pays those fees. In Montgomery County, it's that's the only county we have to pay the attorney ad litem fee up front, retainer. It's $400, but I've had 4 or 5 cases in Montgomery County where they didn't charge anymore. Waller County, probably between 400 and 500 in Waller County.
Okay. Thank you for sharing that with us. I'm going to launch a couple of polls, and then I'm going to talk to the slide in just a second. So we want to kind of know who's here today and kind of what your biggest concerns are on as it relates to special needs planning. So you should be seeing a poll on your screen right now. You guys can select as many as are appropriate for you. We'll give it just a few more seconds here. We do a lot of webinars and educational events on a weekly basis, and this poll is, basically helping us understand kind of what are some of the biggest needs and concerns that you guys have on your plate right now. So that definitely helps us with that. We've got about 17 that have voted. We've got a few more. I'm just going to give it just a few more seconds, maybe about 10 more seconds, and then I'm going to end that poll. Okay. And I am going to share the results, see if you can see those on the screen. So as it relates to special needs planning, the biggest concerns and tied up are guardianship and future care planning, with a close second to special needs trust, which we will definitely actually we really have webinars on all of these topics, and if you've missed them, we have them on our YouTube channel, and we actually have some additional ones coming up as well. So, so what I would like to do is kind of talk about kind of the slides that we have on here. So again, all of these that we have topics on that we've done in the past. These are all things that should be on your special needs planning radar. The developing a future care plan. There's a lot of questions and confusion around the Texas waivers and interest list. If you have a special needs loved one, you want to make sure that your loved one is on the Texas waivers and interest list, and you're going to check with your LIDA, the local intellectual disability authority, to get on those lists. And these lists that I'm talking about are Texas Home Living. I'm talking about HCS. I'm also talking about class. There's a separate phone number to get on the class interest list. We spend a lot of time talking about SSI, SSDI, understanding the differences and knowing when to apply. And basically, a lot of families, their disabled kids don't qualify for SSI and Medicaid all these years, 18 years, they don't qualify because basically you have too much assets. If your assets are more than $2,000 if you're single, or $3,000 if you're married, you won't qualify. But as soon as your child turns 18, it's based off of your child's assets, not yours. So even if you've been denied before for SSI and Medicaid, you want to put it on your radar to apply for SSI and Medicaid when they turn 18. I would call a couple of months in advance to schedule your appointment for the birthday month. The month that they turn 18 is when you can apply, and you can schedule that appointment for that birthday month a couple months in advance. If you actually call their birthday month, it might be 2 or 3 months before you actually, get that application in over the phone. ABLE accounts and special needs trust are two places that you can have money for your special needs loved one above and beyond that $2,000 that SSI kind of mandate. You can have money in an ABLE account and a special needs trust that will not be counted against them for the means-based test for SSI. Beneficiary designations. If you have a loved one that is on SSI and getting Medicaid, it is very, very important that you yourself as a family, your parents, grandparents, other loved ones that might leave your loved one money, that the beneficiary is set up to the special needs trust and not to your named loved one directly, because it can cause them to lose their SSI and Medicaid if they kind of inherit, or they get that money that they weren't planning on. So we've talked about guardianship, power of attorney, healthcare power of attorney, and supported decision making today. We have a lot of topics surrounding post-high school options for people with disability. There's a ton of programs out there, certificate programs, degree programs, transition programs, what have you. And so you want to be researching those and kind of looking at some of those things. We really spend time talking about waiting lists and community-based care facilities, transition programs, things like that. Some of our kids will stay in the public school till 21 or 22. Some of them will be exiting the public school at 18. Start touring, start looking at some of these options, and seeing where we're going post-high school, because some of these waiting lists are long and you might want to get in there. The very last thing that we want to just chat about is post 18. In Texas, if you are in a divorce situation, a lot of times child support does continue, not always. It does continue past age 18 if the individual has a disability. In that example, we're talking about SSI and your child applying for SSI once they turn 18. It's super important that the child support be redirected to a first party special needs trust. This is not a do-it-yourself activity. This is a hire an attorney that works with special needs, kind of get this taken care of. But basically what happens is that child support post 18 will be counted against the individual as income and could cause them to disqualify or not qualify at all as it relates to SSI and Medicaid. So those are a couple of things that definitely need to be on your radar. With that, that's my last slide. You can go to the next slide, please, Boyd, and I'm just going to see if we have any other questions.
Yeah, I just wanted to mention on the child support to a first party special needs trust. Talk to your, I'm not a family law attorney, but talk to your family law attorney. It cannot go, a lot of child support goes through the Attorney General's office. If it goes through the Attorney General's office, then it cannot go into a first party special needs trust. So just bring that up with your if you are going through a divorce with your family law attorney. And in most cases, family law attorney will have a special needs attorney on retainer to explain the ins and outs of the issues with government benefits and how child support affects that. Thanks.
Yes, and boy, that is a big deal because actually, it is important to note that I have had people say before, well, you can just go into that, to the Texas system and just redirect it to a special needs trust checking account. It really doesn't work that way. It doesn't work that way. You might be able to do that in that system, but it's not right. It's not going to fly. And so you definitely do need an attorney as it relates to that there, and it's problematic. So again, if that situation is you might want to start that process sooner versus later. Ideally, in that situation, if we have two willing parties, they can put it together and get it signed off on, by a judge or what have you. But it is important that this happens, and if it hasn't happened, you might want to delay applying for SSI and Medicaid. So that was kind of the main thing behind that. Well, ladies and gentlemen, we've had a great presentation today, Boyd, and you finished 15 minutes early, so that's awesome. Thank you for that. All of our contact information is here, and again, today's recording has been recorded, and we will be sending this out to everyone later today or tomorrow. If you have any additional questions for Boyd, if you've had, situations, I know anytime we have a number of people on here, everybody's situation is a little bit different, and you want to kind of run that by Boyd, certainly feel free to reach out. And Boyd, we would just like to thank you for being here with us again today and giving us this great presentation. So thanks so much, everyone. Have a great afternoon. Take care.